Welcome to Dorsey and Whitney's webinar on L&E Briefing, OSHA's COVID-19 vaccine or testing requirement, understanding the new rule and how to navigate it. I'd like to introduce Jillian Kornblatt, a partner in Dorsey's Labor and Employment Group. Jillian?
Thanks, Sean, and thank you everybody for attending this morning. We have a lot of material to cover due to recent federal action, and so we expanded. We're going to go for 75 minutes. We most likely won't have time for Q&A, but feel free to reach out afterward. I'm talking quickly now, and we're going to try to go through quickly so we can get you as much information as possible. To introduce our panelists, Steve Lucky is a healthcare litigation partner. The rest of us are all L&E attorneys. I'll note that Allison and Aaron are in our Seattle office. Katie is in our Iowa office, and the rest of us are in Minneapolis. So with that, we will go to kind of an overview of what we're going to cover today. And I won't delay here. You can all see that on the screen. And so we'll go to our first topic, and Allison is going to explain who is covered by this ETS OSHA just issued.
Thank you, Jillian, and good morning, everyone. Generally speaking, the OSHA Emergency Temporary Standard will apply to all employers with 100 or more employees. We'll call them large employers, unless they're subject to the CMS rules or other vaccination requirements for federal contractors and subcontractors, which Katie will explain in a little bit. But when we're counting 100 employees, we're counting employees company-wide, not per site. So if you have 100 employees spread across 10 sites, and that's 10 employees at each site, that company is still covered by the ETS. The ETS does include part-time and seasonal employees towards that 100 employee threshold. And it's really important to note that companies that vary in their head count, once a company is subject to the ETS, they'll remain covered by the ETS for the duration of the standard. If you dip below 100, you don't automatically have to stop complying with the ETS. Employees who report to the office are the employees that are covered by the ETS. Employees who do not report to a workplace where coworkers or customers are present aren't subject to the testing or masking requirements, but they do count towards that 100 employees. And it's also important to note that some state OSHA departments may adopt more rigorous safety requirements in the coming week and a half or so.
Thanks, Allison. And so to be clear, so employees who report to any workplace whatsoever, I believe there's an exception for employees who work only outside. Is that right, Allison?
Yes, correct. Thank you, Jillian. Employees who work exclusively outside, and that means outside, not outside and sometimes in a vehicle. Only outside are also exempt from the testing or vaccination requirements.
Great, thank you. So for all those employers, what do they have to do?
So employers have two options. They can either adopt a mandatory vaccination policy, which mandates vaccination as a condition of employment, and includes all of the availability of exemptions for employees under Title VII and the ADA, as we'll explain later. Or they can opt for option 2, which is a vaccination or testing policy. So it would require employees to be either vaccinated or undergo testing on every 7 days. And the testing requirement for is only for unvaccinated employees, but also includes a masking requirement where employees are required to wear a face covering at all times with certain exceptions while in the workplace. Employees who report to the office irregularly, so someone who works from home half of the time or less, would need to submit a proof of a negative COVID test within 7 days of going into the office. And employers are not required to pay the costs associated with the testing under the vaccinate or testing option, unless it's required by a state law or otherwise required by a collective bargaining agreement.
Thanks, Allison. And we're going to take a deeper dive into the cost of testing issue a little bit later.
Yes.
So what is required in terms of vaccination?
So in terms of vaccination, first and foremost, for all employees, Employers are required to determine the vaccination status of each employee and create a roster of the vaccination status of all of their employees. Now, this is going to be complicated for employers who collected some sort of proof of vaccination prior to the ETS being published. Employers who collected proof of vaccination prior to the ETS being released will not be required to recollect the proof of vaccination, but they will be required to collect proof of vaccination for all new employees. Also, employers who collected attestations prior to the ETS being released will be able to use those previously collected attestations as proof of vaccination, but cannot continue to collect attestations. They must require proof of vaccination, which I think Erin will get into in a little more detail later on.
Okay, thanks, Allison. And of course, people's vaccination status may have changed since an earlier collection. So that's something, you may want to ask employees to update. Okay, so moving on for the unvaccinated employees, what do the employers have to do there?
So employees who are unvaccinated must submit proof of a negative COVID test every 7 days. And employees who are not regularly reporting to any workplace would need to provide that proof of a negative COVID test within 7 days of reporting to a work site. But employees who exclusively work from home and do not interact with any customers or colleagues will not be required to submit proof of a negative COVID test every 7 days.
Okay, so for employees who are mostly remote but come in occasionally, they have to show a test result taken from the 7 days before the interacting with other people. Is that correct?
That is correct.
Great, perfect. All right, so oh, go ahead.
Sorry, those unvaccinated employees are also required to wear masks at all times when they're in the workspace, except when they are alone in a room with floor to ceiling walls and the door closed for a limited time while they're eating or drinking, if they're wearing a respirator or a face mask as defined in the ETS, or if an employer can show that wearing a face covering is unfeasible or causes greater hazard, such as if an employee is using some sort of machinery that could get caught on a mask, something like that. The ETS also includes diagnosis requirements for employers, and this applies to all employees regardless of their vaccination status. If an employee tests positive for COVID-19 or is otherwise diagnosed, they need to be removed from the workplace immediately, which means that employers also need to require employees to provide prompt notice of any COVID-19 diagnosis. And employees are required to remain out of the workplace until they meet the CDC requirements for return to work, which differ based on vaccination status.
Thanks. And so when does this all need to be done?
Okay, so most of the requirements of the ETS need to be met by December 5th, 2021, including establishing a written vaccination policy and distributing it to employees, and all of the notice requirements that Erin Goldstein will get into in a little bit. You'll also need to maintain a roster of employee vaccination status, which can be reviewed by OSHA at any time. By December 5th, employers will also need to require facial coverings for unvaccinated employees. And the public comment period on the ETS also ends on the 5th. By January 4th, so 30 days later, employees must either be fully vaccinated or unvaccinated employees must provide proof of a negative COVID test every 7 days. So all of the requirements except for the test or vaccinate requirements go into effect by December 5th. And on May 5th, the ETS will expire unless OSHA has issued a final rule congruent to it.
Thanks, Allison. So now turning to state law. So Katie, I mentioned you are in Iowa, which has a state law addressing some of these issues. What is an employer who operates in states with those kinds of orders to do?
Sure. Good morning, everyone, and good morning to all my Iowa friends on the call. As Jillian mentioned, our state legislature was in a special session a couple of weeks ago to do redistricting, and as part of that passed a law related to vaccines in the workplace. The governor signed it, and it was basically in effect for just a few days. So it's been a little bit of a roller coaster for Iowa's employers, who now may fall under the OSHA ETS and are trying to figure out what to do, because our state law conflicts with the OSHA ETS. There's other state laws. The Texas law, I think, was the first one that maybe came out sort of in response to the Biden administration's announcement. And then Alabama, I believe, signed a law late last week. So the ETS is very clear that it preempts any of these state laws. It's in the ETS itself, and there's long explanations as to why that is. So if you operate in a state that has a law about employee vaccinations and you are subject to the ETS, then you must follow the ETS. And this includes the standards for available exemptions. So in Iowa, there are additional exemptions available beyond what the ADA requires. And if an employer is subject to the OSHA ETS, they need to follow the exemptions set forth in the ETS with reference to the ADA, not those broader laws enacted by some of these states.
Thanks for breaking that down, Katie. It is a complicated issue.
So the ETS is meant to be a floor and not a ceiling. There are, much to my surprise, I've gotten some questions from clients in the last 48 hours saying, can we do more than what the ETS requires? And the answer to that is absolutely yes. This is the minimum. If you fall under the ETS, this is the minimum of what you must do. But if an employer decides to do more than what the ETS requires, what that is effectively a voluntary vaccination policy. So if you decide that you want to do more than what's required by the ETS, then you do need to be aware of state laws, because you're not enacting a policy to comply with an OSHA rule, you're enacting a voluntary policy, and voluntary policies would fall under the requirements of state law. So you kind of just have to make those determinations, what's best for you and your business and your employees, and then figure out which law applies once you kind of figure out which direction you're going. This was on the previous slide. I neglected to mention that, but the ETS makes clear that to the extent states have laws that provide more protection against COVID-19, or they have laws that relate to COVID-19 but do not relate to employees specifically, the ETS does not preempt those laws. So I know some states and localities have rules that may say you have to have a vaccine in order to come into a restaurant and be served food. That kind of law still applies regardless of the OSHA ETS, because that doesn't deal with employees, it deals with the public.
Thanks, Katie. And as related issues, what about states with their own OSHA departments?
So states do have the option to adopt plans for workers in line with what the ETS says. So if a state has its own OSHA plan, it has to enact a policy or a rule that's at least as restrictive or has the same amount of coverage as the ETS. Of course, states are free to provide more coverage. You know, states like Texas and Iowa and Alabama that's not going to happen in states like that, but it could happen in some states that have been more aggressive with their COVID-19 policies. The difference is that the OSHA ETS does not apply to state or local government employees. But if a state did enact its own state OSHA requirement with regard to vaccines, then that would apply to those public employees.
Thanks for breaking that all down, Katie. Now, so that's interaction with state law. What about interaction between these various federal new laws that have gone into effect?
Sure. So I'll try to just go through this relatively quickly, taking us all the way back to June of 2021. There was a healthcare emergency temporary standard that was enacted for certain healthcare employees. Then in September, the executive orders came out for federal contractors and federal employees. And then most recently, we got not only the OSHA ETS, but on the same day, Center for Medicare and Medicaid Services issued their own vaccine rule as a condition of receipt of Medicare and Medicaid funding for healthcare providers. And so there's a lot of people who are, for example, healthcare employers who are trying to figure out which of these guidelines they're supposed to follow. So CMS sort of reigns supreme in the hierarchy of all of this. If the CMS rule applies to a particular employer, then they need to follow the CMS rule. If CMS does not apply, but a employer is a federal contractor, then the federal contractor rule applies. Even if that federal contractor has 100 or more employees, they have to follow the federal contractor rule, not the OSHA ETS. And then if they're not a federal contractor and they're not subject to CMS governance, then if it's a healthcare employer that was subject to the June ETS, they can continue to follow the June ETS, which does not require vaccinations. If not a healthcare employer and 100 or more employees, then the employer would follow this new ETS that we're talking about. If none of those apply, then those state or local laws that we discussed would apply to any voluntary vaccine policy.
Thanks, Katie. That hierarchy is really helpful because obviously a lot of employers are subject, they fall into multiple categories. So thank you.
Yep.
And that's not all on the legal front with the ETS. Jack, what is going on in outside the legislation area?
Well, good morning, everyone, and thanks, Jillian. Well, enough is happening in this area that this slide is already out of date. There are now 13 lawsuits pending in federal circuit courts. These are across the country: 5th, 6th, 7th, 8th, now the 9th Circuit, and also the 11th Circuit. Everyone on here may be wondering, what do we do given that there are all these legal challenges? The nature of the challenges and what's being argued really could be the basis of a full hour of analysis and conversation. I think the highlights for people to be aware of is there's a lot of people attacking the ETS, governments, individuals, employers, advocacy groups, that some of which have formed specifically to attack the ETS. Some unions have filed cases against it. And really there is, at this point, it is difficult for anyone to predict the outcome of this. The ETS is an authority that OSHA has, that it's had for a long time, but it doesn't exercise often. And the bulk of ETSs that have occurred in the past date back to the 1970s. And so it's really hard to know, to look at what happened in those cases and extrapolate any sort of prediction about what's going to happen here. We can advance to the next slide, please. Everyone may have heard, well, I thought a court has stopped this, and that is true, but only in a temporary basis. So one of the appeals courts that has one of these cases issued a temporary stay, and that just means this order may not be enforced until we figure out what's going on with this lawsuit. They issued that almost immediately after the ETS was out. Obviously, and as Allison had explained, the first effective date that we're all going to be facing is December 5th. So that's still in the future. But it opens the question, what should we be doing right now, given this court challenge and these many court challenges? We've talked about this a lot, and it is clear that because it is impossible to predict the outcome of these cases, no employer should put all their eggs in the basket of hoping and assuming that at the end of the day, this order and these mandates are going to be struck down. Instead, the best practice for all employers is to really understand what the ETS requires of you, take steps to comply with it, develop a policy that would comply with the ETS, figure out what you will need to do on the assumption that this will occur on the schedule that OSHA has set out. And then when, or perhaps if, the ETS is affirmed, and that's a question that may ultimately not be decided until it reaches the Supreme Court, given the multitude of arguments that are being made at this point, you'll be ready. And if the ETS is affirmed, you'll be able to apply it. If the ETS is struck down and the Supreme Court has the final word and it says that this is not going to happen, then you would have made an investment of effort that would have been valuable, but that you can then step aside and not enforce. But the key takeaway is given the state of uncertainty and the mandates and details of the ETS, the responsible thing for employers to do at this moment is to assume that it will take effect and prepare to comply.
Thanks,
Jillian,
Jack.
can I jump in just real quick on
Absolutely, Katie.
on the random assignment? And Jack, correct me if I'm wrong, but in the event that these challenges are all consolidated and then they are randomly assigned together to one specific circuit, isn't it possible that circuit could lift the stay and say the judge could say we have a different interpretation and we're going to lift the stay and move forward?
That's absolutely right. Yes. So the Fifth Circuit, which is the appellate court that governs or kind of covers the territory in the south central part of the United States, they're the court that issued the stay. None of the other courts of appeals have issued a stay. The random selection that Katie referred to, so the federal court has this, all federal courts have this process where when you have a multitude of cases that are effectively addressing the same issue, a party, and in this case OSHA, has already taken this step. They can basically ask, we can't be having this fight in 6, 10, 13 different courtrooms at the same time. Let's get them all assigned to the same court and then have that court decide everything. And so that they've made that request, and we're waiting to learn where all the cases will be assigned. It's a random process. It might end up at the Fifth Circuit, which is the court that has already issued the stay, in which case I think we would expect that maybe nothing would change with that regard. Or it could end up in a court that would, as Katie noted, lift the stay and basically say, we're going to decide the issues in this case, but we're not going to suspend the enforcement of the order in the meantime.
Thanks, Jack. And I guess I'd say, so that it sounds to me like what you're saying is, and there's one good piece of clarity in this giant tangle, is that the actual part of it, a test or vaccine, will not be effective until January 5th. So it's possible that it's some or even potentially all of this could work itself out before the employees actually take those steps. Is that fair?
That's absolutely true. And I think the speed that the Fifth Circuit acted when it issued the stay shows the sort of thing that courts can do when they're confronted with a situation like this. At the same time that it issued the stay, the Fifth Circuit entered a briefing schedule. So the deadlines by which the lawyers on both sides had to submit their written arguments. And those were very aggressive. I mean, in a matter of days, they were turning around arguments and counter arguments. And so this would almost absolutely not be a situation where the case is going to proceed at a schedule that we might be familiar with, over weeks or months. Whatever court ends up with all of these cases will be aware of those deadlines and will be aware that, a fast decision will be have value given the situation, and could very well set as aggressive of a schedule to make it so that their final decision is out well in advance of the January compliance date.
Great, thank you. So moving on, so between now and January 4th, a busy time for those of us who are in human resources and employment law. Aaron, what are employers to do?
So Jillian, before I touch on that, I wanted to say a few more points about the, will they or won't they, will the ETS be upheld or not? Because it's a question that I get constantly. And I know that a lot of employers are on a lot of pressure, especially in states where there's a lot of resistance to the mandate, to say, hey, look, we've got to just keep the lights on today. And so we're going to just pause this. We're not going to enforce. We're not going to move forward. I want to just emphasize, I think that's a very risky play for a couple of reasons. One, it really isn't knowable whether or not this is going to be upheld because some of it depends on facts on the ground, which are changing daily, right? One of the things that you need in order to have a ETS that holds up is an actual threat. And if COVID numbers plummet and stay low, that could undermine the ETS. If COVID numbers shoot up again, after Thanksgiving, that could be a lot of strong evidence to support the ETS. And so if there's one thing I've learned about the coronavirus pandemic is don't make any solid plans because things are going to change. Another issue I wanted to raise, which is somewhat relevant to the policy drafting issue, is that the OSHA and the government have issued statements saying that a lot of the enforcement they expect to happen through whistleblowers. And so even if this ultimately gets struck down, if you've got employees who are saying, I demand that the company follow this, and you take any kind of adverse employment action against those individuals or discriminate against them in any way, you could get in trouble even if the mandate ultimately gets struck down. And so folks who are taking a less cautious attitude with adopting these policies and who have employees who are angry that the company isn't following the ETS, they could have individual liability there anyway. And in every state, you don't have to be right as an employee who's making a claim or asserting a right in the workplace. You just have to be asserting that right in good faith. So again, even if the ETS is ultimately struck down, if you have employees that are complaining because you're not following it, you have to be very, very careful about how you treat those employees. So with that little tail point there, I'll get into about drafting compliant policies here. And this will be a very nuts and bolts discussion. I'm going to retread a couple of things that Allison covered quite well, but I think it's important to go over what has to be in your policy. With everything that's going on, it can be easy to miss just the regular blocking and tackling of what do your employee policies have to say. And so under the ETS, companies have an option to adopt one of actually three kinds of policies. You can put them in three categories. You can adopt a mandatory vaccination policy that just requires all of your employees to be vaccinated unless they're entitled to a medical or religious exemption. And Allison did a great job of breaking that down. Alternatively, you can adopt a policy that allows employees to either get vaccinated or be subject to the weekly testing regime that Allison described. And good news for everybody, OSHA has released samples for each of these two kinds of policies. Another option that employers have is to adopt a mandatory vaccination policy for some of their employees, but then a testing or vax policy for others. So kind of a hybrid. And why would employers do this? Some employers might have a group of employees who are customer facing, who have to work really close to other people, or in other situations where spreading coronavirus is more likely. You might have other individuals who, maybe they don't fall into the outdoor only category, but you believe that the chance of spreading COVID amongst those employees is pretty low. And so you're going to give them a test or vax option. One thing to keep in mind, as with all things labor and employment, if you're treating one group different than another, you at least have to consider potential discrimination claims. And so, one possible claim would be the group who are vax only claim that, they're disproportionately, they have religious objections or something like that, or they're in some protected class, and therefore it's unfair to them. So just do keep in mind when you're picking who's subject to mandatory vaccination and who's can vax or test, are you picking on any particular group? And finally, employers really should consider which of these three types of policies will best serve their needs. One big issue is your ability to maintain compliance. Is half your workforce going to quit if they don't have the testing option? Another issue is the cost of testing. Testing could be expensive, notwithstanding the ETS statement that you don't have to pay for the cost of the test itself as the employer. You still may and likely do have to pay for the time spent being tested. And so that could add up to a lot of money. And lest we forget, customer preferences are also very important. If you need to tell your customers everyone's vaxxed who doesn't have a religious or medical exemption, that might be important for your customers versus a vax or test option.
Thanks, Aaron. Those are all great points. And on that hybrid approach you mentioned, another way it seems that might come up is if some parts of your workforce are covered by the federal contractor mandate, but others are not. So you could have a different approach there. Would that be right, Aaron?
Yes, absolutely. And that's a complicated analysis depending on workplace by workplace. The contractor mandate applies workplace by workplace, not employer by employer. So if you are a federal contractor, but you have workplaces that aren't subject to the federal contractor mandate, you're going to want to figure out exactly what your obligations are in each place. And as Jack said, in regards to the Will This Survive legal challenge, there's a lot of topics here that could be an hour-long webinar in and of themselves. And that's definitely one of them. So I'll start running through here what has to be in your policy. First of all, you got to have in your policy information regarding the scope of the vaccination requirement. And that's going to be, as Allison described, all employees except those who do not report to a workplace with others present, right? When meaning others, that's coworkers or customers, folks who work from home, or folks who work only outdoors. You want to have the applicable exclusions from the written policy listed out. Now, anyone who's actually read the mandate, the ETS, knows the way they've described this is kind of odd. They describe it as three categories. One, people for whom the vaccine is medically contraindicated. Two, people who need a delay in getting vaccinated. For example, someone who had monoclonal antibody treatment and it wouldn't be safe for them to be vaccinated, but only for a period of time. And then finally, people who need a reasonable accommodation, either because they have a disability or because they have a sincerely held religious belief. Really, I think it's easier to think of these as two categories: medical accommodations and religious accommodations. I wouldn't let these three categories confuse folks too much. And Katie's going to dive into this more, but it's really employees who have a doctor's note saying you shouldn't get vaccinated, and then employees who say, I've got a sincerely held religious belief that prohibits me from being vaccinated. And then next, you also have to include in your policy information on how an employee's vaccination status will be determined and how this information will be collected.
Aaron, you used the word next, and I had an immediate reation. So now we're on the next slide. I'm like Pavlov's dog. Next.
Yeah, no problem. As we'll get into in some of the later speakers, you're going to have to include information regarding paid time and sick leave for vaccination purposes. There's that requirement that you provide both paid time and sick leave for folks who are getting vaccinated. You need to include the procedure for notifying the employer of a positive COVID-19 result, and the policy for removing folks who have contracted COVID-19 from the workplace. And so you got to let your employees know, hey, if you get sick, this is who you're supposed to tell and how. Next, you need to let employees know how you as the employer are making required information available to these employees. And I'll cover that in a later slide. There's some very scripted information that employers have to give to all their employees. You need to include a description of any disciplinary action for employees who do not abide by the policy. And there, I think it's worth pausing and talking a little bit about that. There's been some information released that employers have some flexibility on how to handle discipline. You don't have to fire someone immediately as soon as they're non-compliant, you're allowed to try to convince that employee to become compliant over a period of time. But sort of going back to the point I made earlier, this is not a basis for avoiding the requirements of the OSHA ETS. If you have an employee who refuses to get vaccinated, you can't say, 5, 6, 7, 8 weeks later, hey, we're still working with this employee, we're hoping they're going to get vaccinated. I'd be very cautious about taking more than 3 weeks or so to go through a disciplinary process for an employee who's refusing to get vaccinated. If they are requiring extra time to get vaccinated, if they're telling you they're going to comply and they're just being slow about it, you can give more flexibility. But I think you're going to get in trouble if you have an employee that's just completely refusing to get vaccinated and you just let them stay active as an employee for weeks and weeks under the ETS.
Thanks.
Oh, go ahead, Jillian.
Oh, I was going to say, you mentioned whistleblower claims earlier, and it seems to me that employees talk to each other and know things about who's been vaccinated. So this area of being very slow to act on disciplinary action could lend itself to a whistleblower claim.
Absolutely. And I really think that's going to be, if the ETS is upheld, whistleblower actions are going to drive enforcement completely. I think we had one more on the last slide. I don't have them memorized. No problem. And then also the procedure for an employee's return to work after a positive test, right? So what's someone supposed to do to get back into the office after they've tested positive for COVID?
All right.
Can I just say something real quick on the whistleblower aspect of it? The healthcare ETS that was issued in June, about a month after that was issued, OSHA put out basically a guide for OSHA inspectors how to do a workplace audit. And it effectively was helpful for employers how to survive one of these audits. And in that guidance specifically, they said in terms of what workplaces we're going to go out and survey for ETS compliance, it's going to be places where there's been a COVID death or places where employees have complained. And so I think, just to your point, Erin, that whistleblowing is going to really drive compliance. Obviously, we know that realistically, OSHA can't come and check out every workplace and make sure that they're complying, but those are the two workplaces that can almost guarantee they're going to get a visit from OSHA.
Yeah, excellent point.
Yeah, I mean, if we remember during lockdowns, the way, I know, speaking in the Seattle area where I'm at, the way the rules during lockdowns regarding essential businesses were enforced were almost entirely whistleblower driven. And boy, were there a lot of whistleblowers. So quickly moving through the requirements for a test or vaccinate policy. Likewise, you have to include the scope, but you also have to include the scope for unvaccinated employees. When does the testing option apply? You want to include information regarding the additional masking and social distancing requirements for unvaccinated employees. And quick little reminder, they have to, unvaccinated employees have to mask regardless of community spread, unless working alone, eating, or it would be dangerous for a person to be wearing a mask. And then next, also information regarding how the testing procedure is going to work. So weekly for folks who are regularly in the office, at least 7 days before entering the workplace if you're remote or have been away from the office for a while.
Thanks, Erin. And I'm going to have to ask you to kind of breeze through our tips here because we want to make sure we have time to get to all the other important topics.
Absolutely, Jillian. So the OSHA, use these sample policies as a starting point. OSHA's given you a couple to start. You want to make sure, don't just cut and paste this language into your handbook. Make sure it's consistent with your company's style and culture so that your employees will be more receptive to it. Use this drafting process to learn the rules. By actually going through and drafting this policy, it'll cement what you're required to do. Make sure that this policy is accessible to all of your employees, perhaps via intranet, and definitely consider expanding the section on medical and religious accommodations. So those sections in the policies are very thin, and if you can provide employees with some information such as who they contact about an accommodation, where the forms for the accommodation can be found that they need to fill out, and an explanation about, the company might ask follow-up questions. That'll help ease employees into the accommodation process, because we found it to be relatively litigious with several employees.
That's a nice understatement, Aaron. Several employees, lots of those, right?
Yeah, yes.
So,
Go ahead.
nope,
Okay.
I was just gonna move us on.
Yeah, no problem. So there's some more nuts and bolts information. I had mentioned before that employers have to disclose certain information to employees, and this is really as easy as printing out some sheets that are available online. The first is this key things to know about COVID-19 vaccines. Employers have to provide employees with a copy of this specific article. They also have to provide employees with the anti-discrimination and anti-retaliation requirements of the rule, and also the rule against knowingly supplying false statements or false documentation, for example, faking a test or faking a vaccine status. OSHA has published a fact sheet for these last 2 points as well. So really, you just want to download these fact sheets and the key things to know articles and make sure you're providing them to all your employees. There's also requirements for things that employers have to disclose to OSHA under the right circumstances. First, if an employer learns about a work-related COVID-19 fatality, you've got to let OSHA know within 8 hours of discovering the fatality. An employer also has to let OSHA know within 24 hours if the employer becomes aware of an inpatient hospitalization for COVID-19 that's work-related. Employers are generally not required to report deaths or hospitalizations where the employee is working remotely, but the OSHA rules here, the OSHA ETS, they incorporate OSHA's general rules for determining work relatedness, and these are kind of arcane and wacky, and so you're going to have to get some additional guidance for the areas that are kind of gray. If you have a workplace outbreak, someone who's been in the office and has COVID, you should treat that as work-related. If someone's completely remote, you can probably treat it as not work-related. But if it's anywhere in between, you should seek additional guidance.
Thank you. And I think in the interest of time, our record-keeping obligations, there's some guidance there in the slide. But I think we'll move past that unless, Aaron, there's anything particular you would like.
Just the quick point, you want to treat the records themselves that are generated, the testing and the vaccination records, as strictly confidential. Don't share the records themselves. The information about who's vaccinated, who's been tested, and who's tested positive, you want to share that information only on a need-to-know basis.
Good morning, everyone, and thank you, Jillian. For the first time since the end of 2020, I'm able to say that there is a new federal paid time off obligation and paid sick leave obligation. And unfortunately, that requirement is much more subjective now than the requirement that existed under the FFCRA. And Jillian, if we can actually go back one slide. The obligation that exists right now is a PTO obligation with respect to the time that it takes to actually receive the vaccination doses. And then the second requirement is a paid sick leave obligation for the employee to recover from the side effects from those vaccine doses. And I'm going to talk about both of those in separate part. Jillian, do me a favor and move back one slide.
Sorry about that. I must have accidentally clicked twice.
This is the correct slide. And we're going to start talking about the paid time off obligation for employees to receive the vaccine doses. And the general rule is that the employees can receive up to 4 hours of paid time to receive the doses, and a reasonable time for the paid sick leave obligation, which we'll talk about in just a moment. But I want to make one point very clear, which is this is not automatic. The employees can receive up to 4 hours for the doses. But if it only takes an employee 1 hour or 1.5 hours, that's all that they get. Additionally, reasonability is an important caveat here, because if an employee requires more than 4 hours, so say you have an employee that's in the state of New York and transit is much more difficult than it might be somewhere like Minnesota or Iowa, that employee, if it takes them more than 4 hours, as long as that is reasonable, they will not get paid time off beyond the 4 hours, but they also can't be disciplined or discharged in any way as long as, again, it is reasonable, the amount of time that they've taken to get the doses.
That's a great point, Drew.
And those four hours, they're generally tethered to OSHA making predictions about the time it takes to travel and the wait time pre-shot and the wait time post-shot. And I'm not going to get into those details, but that's how OSHA reached the idea of 4 total hours. The second requirement, which is on the screen, is a paid sick time obligation. And that's for the employees after they get the vaccine doses to recover from any side effects that they may experience. And it's worth noting that both of these requirements, the PTO requirement and the sick leave requirement, relate to those employees who are getting vaccinated. There is no paid sick leave or PTO requirement for employees that are getting tested on a weekly basis. For recovering from those side effects, the key word is, again, reasonability. An employer is required to give paid sick leave to any employees who are suffering side effects in a reasonable amount of time. If an employer has an existing paid sick leave policy, it is okay to require employees to use that paid sick leave in order to recover from the effects that they receive from the doses. But it needs to be at least as generous or more generous as the requirements for OSHA. In other words, if the employee has a reasonable need for paid sick leave to recover from the side effects, the employer can't say no. They can't say we have an existing policy and you're out of time. And in the same way, an employer cannot require an employee to use personal time, vacation time, or to go into the negative in an existing sick leave policy. So you can't require the employee to, for example, accrue PTO or dip into future sick leave obligations that may exist. If you require an employee to go into the negative because this is a brand new sick leave obligation, that would not be compliant.
Thanks for getting through all those particulars, Drew. That's going to be really important as people go to implement this.
And then this slide, we're not going to spend a very, very long time on, but it's worth reminding everyone that there are state and local laws regarding paid time off. And just because it's not federally required, that isn't the end of the conversation. States are able to enact more generous paid time off requirements, in which case they wouldn't necessarily be preempted by the federal OSHA rules. So for example, even though the requirement under OSHA is 4 total hours, 2 hours per dose, in the state of New York, there's a rule that there's a law in place that employees can get up to 4 hours per dose for a total of 8 hours. And so that's an example that employees in New York might be subject to a more generous rule than exists federally. And frankly, this is yet another reason why companies need to be wary of workers in states where you might not have operations. And we've been advising clients of that for months, if not since March of 2020. But with the change in the workforce and employees who are able to work remotely from just about anywhere, if you have a rogue employee who may be in a state like New York, this is an important consideration for you because the requirement for the paid time off and the sick leave may be different.
Thanks, Drew.
And then I also want to spend some time just briefly talking about some of the wage and hour considerations, including the costs of both vaccination and testing and the time that it takes to get vaccinated or tested. And I'm really just going to lay a quick foundation, and the incomparable Steve Lucky is going to pick up from there and talk about the specifics as far as employee benefits issues. The slide that we're looking at right now it addresses the time to get vaccinated. And we've already talked about all of this because it really is covered by that PTO obligation on a federal level. And so we don't need to walk through that again, but it's worth just reiterating. Employees are entitled to up to 4 hours with a reasonability standard as far as the time to get vaccinated, and then a reasonable amount of paid sick leave to recover from the side effects from the vaccination. This is a new obligation, and you cannot require employees to use advanced sick leave, accrue negative paid sick leave, or borrow against future paid sick leave. But you may well have an existing paid sick leave policy that would cover this. And so if you think that that's the case, you should consult employment counsel just to confirm.
Thanks, Drew.
The next slide talks about the costs of vaccination, and this is a bit more clear from OSHA, which is that employers are not required to reimburse employees for transportation costs related to obtaining the vaccine. And you can see some examples of those up on the screen. As we discussed earlier, just because there's no federal obligation doesn't mean that there's no obligation. And we're going to talk about that in some detail in just a minute. But I just want everyone on this call to remember that when we're talking about OSHA, there may well be other rules or ordinances or other obligations that apply to you.
Thanks, Drew. Excellent point, because we all know that this will be an important issue to employees.
Yeah. Now let's talk about the time that it takes for employees to get tested. So these are unvaccinated employees who are getting tested on a weekly or near weekly basis. It is not yet known whether the employer is required to pay employees for the time to get tested. And the reason it's not yet known is the Department of Labor has specifically said that it's going to be publishing additional guidance on whether that time is compensable soon. Now, even though we don't know that, I should add a few pieces of caution here. One is for employees who are tested during on-duty time. The answer is almost certainly going to be yes, that this time is going to be compensable and you're going to have to pay employees for that time. And we're talking about hourly employees right now. If the time is off-duty, it's a bit murkier just because we know that there's forthcoming guidance. But at the same time, the general rule is we are cautioning employees that they should prepare as though this is going to be compensable time. And part of the reason for that is that the guidance that has existed before the ETS generally says that if the testing is necessary for the employees to perform their job safely and effectively during the pandemic, then it's compensable. And the entire premise of the OSHA ETS is that COVID-19 presents a quote unquote grave danger to employees. And so we would be relatively surprised, even though the rules will be revisited and guidance is forthcoming, it would be relatively surprising if the rule changes so that that time would not be compensable. Now, one quick point, there are two areas in which employers can consult experienced labor and employment counsel and potentially be able to help themselves in this regard. One is that if time is compensable, in some states, you may be able to set a different rate for testing time, i.e. a lower rate for testing time. Again, I would only do that with the guidance of experienced wage and hour counsel because there are a number of potential pitfalls and it matters very much what states you are doing business in and how you're drawing those lines. Additionally, you may be able to require employees to use PTO for compensable testing time in some states, but again, consult experienced employment counsel before you're requiring employees to dip into existing PTO or sick leave for those purposes. The slide that Jillian has up right now are the costs of testing, and we're going to spend all of 10 seconds on this because it's easy. Employers are not required to pay any cost associated with testing. And the entire FAQ is up there. It'll be in your materials, but really just the first two sentences are what matters for purposes of this discussion, which is the answer no, employers do not need to cover those costs. But if we go to the next slide, just because there's no federal obligation doesn't mean that there's no state obligation. And the 6 states that are highlighted in red on the screen each have some form of a law requiring employers to reimburse certain business expenses incurred in connection with their employment. The catch is that each of their laws are worded a little bit differently, and the wording of the law matters very, very much in this regard. So for example, in California, the employers are required to reimburse all necessary and reasonable business expenses incurred as a direct consequence of employees doing their jobs. In Illinois, it's all necessary expenditures or losses incurred that directly relate to employees' work. Or in Montana, we're talking about expenses necessarily incurred or losses that are in direct consequence in the performance of job duties or of obedience to an employer's direction. And so those little nooks and crannies, the variances between the laws may seem slight, but it can make the difference between whether medical testing costs are going to be compensable in those 6 states. And so it's very, very important that if you're an employer with operations in multiple states, that you're thinking carefully about whether those states might have rules that apply to reimbursement of the costs. I'm not going to spend very long on this slide here either, other than just to underscore that there is a looming legal fight over whether employers in those 6 states will be required to pay the cost of testing. Is vaccination or testing technically necessary? Who is requiring that expense? Is it the employer or is it the federal government? These are all questions that courts and state labor departments are going to have to work through.
Thanks, Drew. And some other states may have a little, like a piece of a business expense that is covered as well. So it's a good idea to take a really close look at any states where you have employees.
Exactly right. And then the final point that I wanted to make is a brief one, which is just, we've talked about one additional source of employee rights, which is state and local ordinance, state laws and local ordinances, in particular with regard to paid sick leave. But you also should make sure that you check your existing benefit offerings. If you have an existing paid sick leave policy, re-review that policy, check your handbook, check and see what benefits exist now and whether there's an entitlement for employees to the types of sick leave and paid time off that we're talking about right now. If there is a collective bargaining element with your company, make sure that not only you're checking the existing CBA, but also that you consider this information for future bargaining efforts. And then one final point, which is a nice send off to Steve Lucky, which is that there is a complex body of case law addressing when a state law mandating that an employer pay for the employee's healthcare needs is preempted by ERISA. And state laws mandating that the employers pay for the employee's healthcare costs could well be preempted by ERISA, and companies may seek to challenge those laws on ERISA grounds. So it's just another important area of preemption everyone should keep an eye on.
Thank you. And because it is never a good idea for employment lawyers to dabble in ERISA, we have Steve who's going to tell us about this aspect about the cost of testing.
Thank you, Jillian, and good morning, everyone. And we've heard a couple of times this morning that the OSHA regulations do not require that the employer pay the cost of testing. But that is not the same as saying that the employee pays the cost of testing because of the overlay of so many other rules and regulations. As an aside, certainly the employer can pay. There are ways for the employer to pay, and there's a lot of reasons that the employer may want to do that, and we're going to address those. But before we do, I want to just focus a little bit on the employee benefits aspect of this. And even if you're in a state where there isn't an obligation under state law to pay for the testing, it's something that you need to consider. Employers cannot, I think, assume that they have no obligation here. And to the extent that an unvaccinated, to be tested workforce comprises a significant portion of the workforce, the potential cost of that should be something that the employer should consider in determining the vaccination policy, employee retention priorities, and also financial planning. And the reason for this is, if you go to the next slide, Jillian, that oftentimes employers tend to think of their health obligations as, well, that's insurance. That's the insurance company that's handling that. And as an initial matter, most large employers, and of course this regulation only applies to large employers, about 80% of them on average, according to one study, are self-funded. And so that means at the end of the day, in one way, shape, or another, they are going to be responsible for the healthcare costs that are incurred. And what we're doing right now is leaving an environment where there is regulations that have required that health plans, essentially, self-funded, insured, and other sorts of funding, basically bend over backwards to cover the cost of testing. Medical, if it's generally speaking, if it's for any kind of diagnostic purpose or medical purpose when referred or administered by a healthcare provider, that it is going to be required to be covered without any cost sharing through the emergency period. That period is currently extended through January, but it's likely to go beyond that. That's without regard to whether the person has symptoms, to whether that person who's being tested has any exposure to someone with symptoms. And if you can go to the next slide, Jillian, that's not to say that the rules aren't clear, that there isn't coverage required for what is considered to be monitoring or surveillance. In other words, public health or social purposes testing. And workplace, school, travel settings quite clearly fall within that. And a lot of the current insurance policies and procedures say that, although it will depend on the actual language of the plans that the employer is sponsoring, that the employer is ultimately responsible for, that if you're self-funded, the third-party administrator is going to be handling. And if it's insured, it's not going to be your risk. It's not always so clear that a test, even for workplace, school, and travel settings, is necessarily for surveillance and not medical related. I think Drew just mentioned some situations in which, depending on the specifics, there may be an obligation to pay for time off for testing, depending on the nature of the safety and the medical situation at hand. There's a case that's referenced here, and it says Alaska Airline. It's actually Aloha Airline, I believe, but the site is there and it's an older case and it has to be taken in context, where testing that was done for pilots to ensure safety of pilots, not their medical condition, but the safety of the passengers, was still going to be a medical benefit. And so those are some gray areas that should let us all know that we shouldn't be surprised if there's going to be some turbulence in analyzing what the health plan coverage is going to be. There's actually, though, a more practical situation that plans are going to have to confront here in terms of whether or not they're going to have to pay for testing, especially when we're leaving an environment where most tests tend to be covered. And the rules are quite clear that there's no real medical management that is allowed. There's no prior authorizations, no medical screening. You don't need to have, although you did earlier, a direct involvement of a healthcare provider. It's basically, there has to be some connection with a healthcare provider, and that would be providing it under accepted standards of medical practice. But typically, you have medical reviewers who are determining whether something is appropriate. And under the regulations, that is not there. And in fact, one of the FAQs said that that plans are to assume that the receipt of a test is an individualized clinical assessment. In other words, for medical reasons. CMS, shortly after those regulations came out, said if you're getting a vaccine, to visit a family member just to make sure that you're not going to infect them, that would be covered. And so you can start to see that there's not a lot of clarity, and it's not going to be immediately obvious why a test is being undertaken. A COVID test doesn't know why it is being given to a particular individual. So it's going to be against that backdrop that plans are going to have to determine through their TPAs and otherwise whether something is going to fit within or without the coverage. And so if you can slip to the next slide, as has been mentioned, there are other sources that would obligate an employer to pay the cost of testing. One is going to be state law that can be a little unclear. Another is collective bargaining agreements, which will be discussed briefly in a little bit. And as I said, that employers can also decide for a variety of reasons. I need this to retain my workforce, or this is just something that I want to do. It may already be a benefit under the plan. The regulations are seem to say that even that an employer could, through their health plan, cover testing. There's going to be a little bit of tension there because health plans are, by definition, supposed to provide coverage for health situations, not other, like the social purposes. But that's in the regulations right now. Not all employees are in the employer-sponsored health plan, and there are some exceptions that are allowed for what's known as employee assistance plans, where there are where they can provide limited benefits. I guess what I would just say is there is a lot of complexity that goes into whether or not an employer is voluntarily providing that coverage, whether that is a plan, even though it isn't expressly stated to be a plan. The employer community, I think, is a little bit divided on whether they want it to be a plan, and DOL guidance is has not been clear on that subject. But it's something you should keep an eye on. And then, of course, there's also HIPAA privacy issues that come up and compliance issues that come up once you cross that line and are providing a plan, particularly if the employer has more involvement in it. And I will reiterate that at this point, I would just keep in the peripheral vision that there may be a conflict between the state law and any kind of a plan that the employer is providing that could affect the calculus. I think it's just worth a brief note that the cost of testing is not insignificant. And there is for lack of a better word, I would say a gap in the regulation that can potentially expose employers to having to pay unreasonable testing costs. Under the CARES Act, the amount of the testing costs that if there is going to be an obligation to test, and it's determined that there's an obligation to test, and the employer is responsible for it in the end, it's the amount that equals the cash price for such testing service as listed by the provider on the internet website. And there has been, these costs have ranged from $20 to several $100s. AHIP is very much on this, and there's been a number of lawsuits throughout the country, not a lot, where the plaintiffs, oftentimes the testing companies, have tried to recover these amounts. And they've conflated the insurance companies with the self-funded plans, and oftentimes seeking amounts in excess of $500. Sometimes the plans or the TPAs have taken the initiative on this, but there's a not insignificant number of these that are quite tested that cost a lot. And so the final slide on this particular topic would just be some things for employers to think about, which is everyone who has a self-funded plan should be paying attention to what those plan provisions say today. Oftentimes they're different, and it's your plan. And do they cover this? Do you want to cover this? Coordination, communication with the TPA is important, and it's also important to be attuned to the role that the employer has, even if it's indirectly, in any kind of resolution of a dispute with a testing company. Typically, an out-of-network provider is working through an assignment. They don't seem to be doing that here. There's disputes about whether there's a private cause of action, whether you can just rely on a posted price, and whether there are some offset and recoupment defenses. And also employers under ERISA's discrimination provision, Section 510, should also be careful about how they determine whether they're going to have a vaccine policy that's going to affect employee benefits.
Thanks, Steve. That's very helpful. And I hope that when the DOL puts out the guidance that you referenced, they will address the issue of if employees are paying for testing, how does that interact with minimum wage requirements and overtime pay requirements? So thank you. This is a topic that we could certainly spend well over an hour on, but Katie is going to give us a brief overview of the medical and religious exemption that Erin mentioned earlier.
Sure. So I won't spend too much time on this because I know we're running short, and this medical and religious exemptions are not something particularly new in the vaccine mandate world. So while a lot of the things we've covered in the ETS are new, the provision of medical and religious exemptions is something that I think a lot of employers have been at least thinking about. So in terms of medical exemptions, these are going to be the fairly easy ones for employers that, as Erin said, someone brings in some sort of a note or certification from a healthcare provider that says, for this reason, the employee cannot either get the vaccine indefinitely, or the employee needs a deferral on getting the vaccine. That kind of documentation is confidential medical information that must be stored accordingly in the same place that you would store another request for an accommodation or FMLA paperwork or things like that. And in terms of what needs to be done, what extra mitigation strategies that employees need to do if they're unvaccinated, those are going to be the same for employees, regardless of whether they're unvaccinated because of a medical or religious exemption or something else. So if you want to move on to religious exemptions, Jillian, these are, I will not sugarcoat this for anyone. These are difficult. They are sometimes maddening. Erin and I have been working really closely with some clients on religious exemptions, and we now have firsthand experience with this, and we feel for all of you because this is a very difficult thing to navigate. So you're looking for employees that have sincerely held religious beliefs, who can demonstrate to you that they live their lives in accordance with those beliefs, not just pertaining to the COVID-19 vaccine, but in other ways as well, whether it's putting foreign substances in their body, whether it's foregoing other medication, whether it's foregoing other vaccines, whatever it is. The EEOC has some guidance on this. I wouldn't say the guidance is particularly helpful because the EEOC really kind of keeps broadening the guidance. They keep issuing additional guidance, but it just kind of keeps getting more broad. But that is available on the EEOC's website. Erin and I did, we published a short article about that that's available on Dorsey's website that you can check out. But I would say on both medical and religious exemptions, when you're looking at those in the context of the ETS, you really want, there's two things that you're trying to balance. On the one hand, you want to make sure that you're complying with the ETS and that folks who are supposed to be vaccinated are vaccinated, and that those who get an exemption, that you have the documentation to show that they are in fact legally entitled to a vaccination. You're also trying to balance avoiding claims of religious and disability discrimination by employees. I'm sure you're all aware of those lawsuits that have popped up. United Airlines is dealing with one. There's lots of healthcare providers dealing with one with them. And so you just want to make sure that you are kind of balancing those two things as you're looking at exemptions. That was a really quick summary, but like I said, we have lots of resources available on our website on that. And then I'll reserve the last minute here, I think, for Jack to talk about union things.
Thanks so much, Katie. And just a quick reminder that that's only step one, right, of this accommodation process. Step two is whether it would be a burden on the company. But yes, to you, Jack, on what if you have unions in your workplace?
Anyone who has a union knows that there is a duty to bargain over terms and conditions of employment. But in this context, it's important to remember that that is on issues where the employer has discretion. So are you going to comply with the mandate? There is no discretion. You have a legal obligation to comply. But that first option, are you going to take option one, mandatory vaccines? Are you going to take option two, vaccine or testing? That is a place where there would be a need to bargain with the union. The only limitation that I would add to that is if you have a CBA, a collective bargaining agreement with your union, then you should carefully look at your management rights clause and any other clause in which the duty to bargain over a health or a safety issue has been waived by the union. In that case, depending on how it's worded, there would be the ability for the employer to say, we've bargained about this and the union has given us the ability to make these decisions. See, here it is in the CBA, and so we're going to implement the policy. So that is the 45-second version of the employer's duty to bargain in this context. Happy to field questions over email after this for those of you who are dealing with this situation.
Thanks. And that's true on all topics we've covered, a lot of new stuff. So there are takeaways. I'll let people read them because we are 1 minute over, but thank you for joining us today.